Off to Dedham, Massachusetts we go. We're going to hear some arguments outside the presence of the jury in the case against defendant Karen Reed, the victim, Boston police officer John O'Keefe. And if you look just behind the defendant, those are the members of the victim's family, his father, his brother, his sister-in-law, devastated at what has happened to their loved one. And can you imagine how uncomfortable this is, such close proximity that she's sitting in at the moment, not looking over at them, kind of just staring off into the corner. Wouldn't you love to know what she is thinking there? Let's go in live and watch.
All right, counsel wanted to see me?
I did, Your Honor. Judge, as I indicated in an email that I sent to your clerk last night and copied to Commonwealth.
I have not seen the email.
Okay, well, I'll explain what was in it. Essentially, I was alerting the court that I would like to be heard prior to the start of testimony today because since Katie McLaughlin testified on Thursday and Friday, we received a deluge of photographs that put her with Caitlin Albert on many different occasions after they graduated high school. We received information from their high school yearbook that they were more than just acquaintances in high school. They were teammates on the track team. And even after I sent that email with the photographs that I attached to it, late last night we received another photo where Katie McLaughlin and Caitlin Albert are standing next to each other in a photo at a baby shower in June of 2021, about 8 months before John O'Keefe's death. It's very clear to us that Katie McLaughlin perjured herself. And I wanted to discuss the issue of the admissibility of not only the photographs that we're now providing that we just received over the weekend, but I also want to resurrect the admissibility of H, I, J, and K for identification. And I think a discussion of this, Your Honor, needs to start with what court orders are currently in place. The leading case with regard to the provision of reciprocal discovery when the defense is offering...
Oh, so you want to get back to Rule 14, the Rule 14 issue?
It is a Rule 14 issue.
Okay.
That's supplemented by...
Hold on one second. So on top of that, we can discuss this later. I'd like to get the trial started.
That's fine, Your Honor. We just... my belief, my strong belief, is that we need to determine this today. And the reason is that Caitlin Albert is coming up as a witness for the Commonwealth. She faces the same areas of cross-examination that Katie McLaughlin faced, and these photos are relevant to her cross-examination.
Okay. All right. So aside from the Rule 14 issue, I also think this is cumulative. I don't have the email. I do have the photos, but we can address this. When do you expect Albert... I'm sorry, what's her name?
Caitlin Albert.
Caitlin Albert.
I'd say midweek, probably. It depends on how far we get today.
So we'll address this either today or tomorrow.
Thank you.
Scheduling purposes. So Sergeant Lenk, is he testifying today?
Yes, Your Honor.
All right, so we need a voir dire of him. I expect that might take a while. Is he testifying this morning, or can we use the lunch break for that? I need to know if it's around 11 o'clock, we'll have a voir dire. I'll just order coffee. I just need to know about that.
So I anticipate 2 witnesses prior to him. So again, I can't predict necessarily how long.
How long will you be with those 2 witnesses?
With those 2 witnesses, probably half hour, maybe a little more with each.
Okay. Any idea how long the cross will be with those witnesses?
Probably, I will handle one of those witnesses. Mr. Yannetti will handle the other, and I would say at least a half an hour on cross-examination, maybe a little bit more.
Okay, would it be up to an hour on each? I'm just, again, scheduling. I'm not limiting you at all, I'm just curious.
Thank you. I don't think we exceed an hour. I would say safely, I know it's a big range, but between a half an hour and an hour, I think, for each of them.
Okay.
I think that's probably accurate.
All right. Paul, can I see you for a second? All right. Thank you. So we will, all set to bring the jurors in?
Yes, Your Honor. Yes, Your Honor.
All right, so while the jury is being brought to the courtroom, let's bring in our guests and talk about what we just saw. Criminal defense attorney and former prosecutor Joe Tamburino standing by in the studio, and standing by remotely, our friend law enforcement expert Sonny Slaughter. Great to have you two this morning. Joe, tell me, as you were watching this, David Yannetti really put a legal conclusion on the record, and the state didn't object to it, saying that this witness perjured herself. Do you agree with that?
No, she didn't perjure herself. If I were the judge, I'd let in some of these photographs. I mean, it does show that these two people knew each other. It goes to her bias or prejudice, whatever it is. But the witness explained this, and this is very common where a witness, I mean, anyone, you, me, could say, look, there's going to be plenty of photos out there with people that I'm with, but I really don't know them, or I did know them at one time, and we just happen to be at the same place over the years. I mean, it's quite common. But actually, to call that witness a perjurer, yes, the prosecutor should have objected. But as we know, the prosecution has missed a number of objections in this case.
You're right, Joe. Yeah, they're apparently asleep again this morning, because I would have stood up, made an objection, made a motion to strike, asked the court to disregard that statement. Because, yeah, I agree with you. Let the pictures in. Let her show, let him show them to the witness and explain, yeah, this was in high school. This was how many years ago? Just because you're in a photograph with someone doesn't mean. The defense is trying to make this gigantic leap to a conspiracy here, and that's what they're trying to do. And I don't know, does it look desperate? Does it look legit? Sonny, how does this look to you?
It's a desperate attempt to connect the dots. I agree with both of you. I would let the pictures in. I mean, let people have the opportunity to explain themselves. The fact that he said that she perjured herself is problematic for me, because it gives the viewers and the jurors who didn't see this, but us, the ability to think, okay, so she's lying? We don't know if she's lying. Can you imagine how many pictures you've been in, and like you're in a picture with somebody, you don't even like them. I've been in pictures, I don't even like people. So, I mean, like, you can't call that it. I mean, because it's like, yeah, we're just in the pictures. They might be the friend of somebody that I'm with, but I don't necessarily care anything for them. And I just think this is, the defense is doing what they need to do as the defense, but I do think it is problematic when you look at the criminal justice system and how it's supposed to operate with truth and justice, and he shouldn't have said that, and it should be stricken from the record.
Right, Sonny. Yeah, and as you were talking, you got me thinking how in trial there are lots of little battles, but not every battle needs to be a war. You pick the battles that are worth fighting. Here, the defense is, I mean, they're trying so hard to make this connection and make this seem sinister. When he said, Your Honor, we discovered information from the high school yearbook that they were more than just friends, they were teammates. How many people did you play on a team with in high school that you can't stand? Or people that you may have liked them and you're friendly, but then life goes on. And I mean, it's just, and it's also like, she's not the only witness saying that Karen Reed said I hit him. There are other witnesses saying the exact same thing. So I don't know if the juice is worth the squeeze.